Beep, 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 beep. Hello, and welcome to the Court of the EDI Jester. We're going down under. Hello, Australia. How are you? I hope you're all well. I know you're all warm. It's like it's roasting over there at the moment, isn't it? Roasting. You could cook an egg on a rock. So, hello, cobbers. Right, here we go. This is important. This is from the Australian.com, and this is really going to be worth watching. Okay, even though we're here in the UK, the opposite side of the world, this is going to be worth watching, and everybody should be paying attention to this particular story. So the story is confronting expert to give evidence in family court puberty blocker case. Now, different countries in different positions regarding this. We've effectively undone puberty blocking for under 18s, haven't we? It's almost impossible to do. It needs to be made completely impossible. But we're all awaiting the outcome of the cash review, as you're aware, which I'm terrified is going to be a whitewash. Because then we really are in murky waters after that, aren't we? If it is a whitewash. Yeah, let's not think about that for the moment. Let's think about what's happening in Australia. So, here we go. A judge will allow a medical expert who believes social contagion has caused a spike in gender dysphoria and does not support endorsing a child's chosen gender identity to give expert evidence in a family court matter, but says the evidence could be confronting and difficult for the child at the centre of the case. Good. Since when did we think that giving a child carte blanche to believe in dangerous cult nonsense wasn't something that you should scare the bejesus out of them about? It is the same as the child who steals for the first time. It's the same. There should be punishment associated with it because it would terrify them. And you have to terrify them out of this, especially if they're young. It's the only thing you can do. The reaction should be so adult, I've said this before, that it terrifies them. A volunteer group that promotes women's-based rights is concerned about medical intervention aimed at the gender reassignment of children by the use of puberty blockers and hormones has been blocked from giving evidence at the court hearing. Right, so they've got this one in, one out. One that hasn't been blocked, one that hasn't. The case regards two Australian parents who are divided over the gender transition of their eldest child and are split over whether a variety of medical perspectives should be presented at trial. The problem I have with this, my good Australian viewers, and everybody else for that matter, is that it should never have got to this point. They're medicalising it by having the trial. They're medicalising by pretending it's a medical issue. It's not a medical issue. It's not a medical issue. It's an issue of reality and psychology. In terms of, not, and I don't mean, psychology isn't a medical thing, but it isn't a medical thing as in changing your body. It should be the second port of call that this child went to. The first port of call should be an education programme designed to frighten the bejesus out of them about the machinations of people like Stoller and John Money. That's what it should be. But yet here we have it. They're in the family courts. How'd it get there? Shouldn't be there at all. It's absolutely bloody deranged. That's the only way that I can view it, frankly. Now, it's when it gets to the family courts, right? Then that can't be a good thing for the child. I'm sorry, it simply can't, that the mother and father go and we'll do this, we'll do that. The mother and father are arguing about this. Now, obviously, one of them is saying no or is against a particular path, and the other one is pro a particular path. How did it get this far? How come the mother and father haven't been told the truth? Sit down with somebody who knows. It's just so heartbreaking. In the judgment about whether they should be able to appear, this person, and testify, the judge said, I accept that the process may still be confronting. I'm not convinced it is likely to be psychologically damaging, she wrote in the judgment. I'm not even convinced about psychological damage. Unless you're talking about people I know, for example, who've ended up in war zones, right? Or women suffering from the most horrendous assault, or men suffering from the most horrendous assault for that matter. I'm not convinced. All right, I think psychological damage is another one of those things we can't pin down. Another one of those things where you say, I can't pin it down, but I know it when I see it. The problem is that people embrace this idea of psychological damage as if it's a daily thing. It's not. If you're that easily psychologically damaged, you are unwell. And then you will take steps to repair yourself, which is what we all do, even if you've broken an ankle. It's basic stuff, isn't it? It's basic stuff. The judge then continues, these are important life-changing issues which require analysis, discussion, evaluation, re-evaluation and assessment. The issues are, by their very nature, confronting and difficult. Ultimately, Justice Christie ruled F, they're using a letter for the name, should prepare a report for the court to consider as evidence. Ordinarily, the court is cautious not to subject children to multiple interviews or assessments, she wrote. I suggest it's the pro-parent that needs the assessment. There's a Munchausen's mother or a Munchausen's father in this. If I asked you to bet £10 with me on whether it's the mother or the father, which way would you go? Would it be it's the mother that's pro or the father that's pro? Put it in the comments. You tell me. Which? If you had to bet, which would it be? In some cases, the judge said, it will be appropriate for there to be additional information available to the court to assist the process of making a best interest determination. I can do this without a court. It is in the best interest of that child that they are stopped from going down this pathway. Australia, wake up. Well, Australia needs to get rid of the bloody lot of it out of their laws. They put it in law, for God's sake. This case comes as the Family Court of Australia continues to grapple with the complexities of gender identity, especially in the content of children, medication and surgery. They talk here in this article at theaustralian.com as if gender identity is real. That's the insanity. They're playing in the same column as the nutters. You've got to get out that column, right? So, boom, here we go. Day one of the court. All rise, my Lord Barry. Good morning, everyone. Thank you very much for coming to this court case. We will be staying in the reality column today, so therefore gender identity is personality, gender expression is fashion. There's no such thing as gender identity itself, and that what we're talking about here is the medicalising of a perfectly normal individual in order to make them look like a simulacrum of the other sex. Is everybody clear about which column we're playing in? Good. You, sir, in the dress, put your column away. That's what it should be. While we allow them to maintain our ability constrain our ability to speak clearly by us playing in their column, this will remain. We don't play in their column. Men aren't women. Gender identity is personality. Gender expression is fashion. That's a child. Sit it down. Tell it what it's going to do. Stop pretending it knows what it's doing. It doesn't. It's deranged. And that derangement will have come from social contagion, which is why getting this individual into the courtroom in Australia is so important. Go and read. There's a lot more to read, but such an exciting development that we will see something happen here that we've not seen before, I think, in Australia. So take hope, my Aussie baddies, right? And, especially my warrior teacher who comes to my sessions with her budgie. We love the budgie, don't we? Okay, so there you go. All right, go and make of that what you will. I think it's interesting. Bye-bye.